Division 1 Court of Appeals is now in session.
Good morning. Thank you. Please be seated. Thank you for your courtesy. This is the time set for oral argument on our case entitled Sarah Janes versus Elizabeth McConnell. Our cause number 1CACV130651. As usual, as both counsel probably understand already, we have reviewed the briefs, we've conferenced the case, we've talked about the issues. I'm sure we have questions for you, and we're prepared for your arguments. Each side has 20 minutes. If counsel for appellants wants to save some time for rebuttal, you need to watch the clock and enforce that yourself, and we'll try to honor that. And if you would both identify yourself for the recording as you begin. We have Mr. Kasparic and Mr. Barnes, so we're glad to have you both. And Mr. Kasparic, go ahead.
Good morning, Your Honors. My name is Tim Kasparic, and I am honored to represent Sarah Janes and her children. I would like to reserve 10 minutes for rebuttal.
All right.
We're here for three issues. It's our contention that the trial court erred by excluding evidence of personal practices of Dr. Campbell, who was Dr. McConnell's defense expert, on cross-examination, where his personal practices were contrary to his standard of care testimony.
Was the Smethers case, if I'm pronouncing that correctly, was the Smethers case cited to Judge McVeigh?
It was not.
And is there anything other than that went on that we should know about other than what's revealed in the transcript? In other words, was there some discussion in chambers or on some other day regarding this issue, or simply what happened during trial when the objection was made and sustained?
There was not discussion. Let me back up a minute. I believe, although this is not in the record because I did not put the voir dire, we did not put the discussions about jury instructions in the record. But with respect to one of the jury instructions that was discussed, the Smithers case was raised, and it was in the proposed. It was cited in the proposed jury instructions. So it was, but that was obviously after the evidence was in and the case was, the evidence was closed. But I believe that the Smithers case was cited in proposed jury instructions that I had submitted. But it was not, I did not cite it at the time that this issue, that the colloquy occurred during trial that I've cited in the brief.
What's your, and I apologize for getting you off your script, but we have our questions as well.
And I would prefer to deal with those.
What's your response to the other side's argument that an offer of proof was not made?
My position is that twofold. Number one, the question that I asked the doctor incorporated his deposition testimony. Number one, the deposition testimony was the sum and substance of his personal practice testimony. When the objection was made by defense counsel at trial, she asked what deposition page, and I cited the deposition page. After the judge, or after Judge McVeigh first sustained the objection, I then asked if I could make a record, and he let me again go through that line of questioning, and it was very clear. It was very clear from the record that I've cited, that I've quoted, number one, that I was referring in the questioning to his deposition testimony, what page it came from, and the deposition itself is part of the record.
Well, in fact, the answer actually came out and then was essentially stricken by the court.
The second time around, that's correct. So I don't think there's any question as to it. And the rule of
the jury heard all that.
Well, the jury, but the judge asked them not to take it into account. So I have to assume that the jury did not consider it in their deliberations.
The point is that the judge understood what the answer would have been.
Absolutely.
Okay.
He knew what it was clear what the answer would have been. And the rule of evidence that's been cited by, or the case that's been cited, only requires that the judge know what the evidence is going to be. That's what the rule of evidence requires. And I think it's unquestionable that he knew what the evidence was going to be, because it came out twice.
As a practical matter, in the course of the trial, had the evidence closed by the time you sat down with the court to address final instructions? Or as,
well, you know,
as some are wont to do,
yeah.
In the course of the testimony of the witnesses, after a trial day, you'll sit down with the attorneys and go through their proposed closing instructions. My question is this: was the court aware of Smithers prior to the closing of the evidence?
I can't answer that now, but I have the minute entries with me, and the minute entries say when we discuss jury instructions, and so I'll take a look at that, and maybe I can answer that question for you in rebuttal. I can't answer it for you right now off the top of my head.
Thanks.
Let me move to another aspect. Let's assume for a moment that we agree with you that it was error under the Smithers case for the judge to sustain that objection. But certainly the argument's been made, and it sounds like it from the evidence, to me at least, that it may not have made any difference. What's your summary of why it's not harmless error, or why it might make a difference? I'm talking about obviously Dr. Campbell, I believe, is saying that I would have made the telephone call.
Well, all I can do is cite you to what this court said in Smithers, and that was that in that case the courts specifically stated, because we cannot predict how a jury would have reacted to this information of personal practice, we cannot say that this was merely harmless error.
Yeah. The problem with Smithers on that is, at least as I understood it, was there wasn't an issue of causation. That wasn't in dispute. Smithers. It was this doctor if the doctor didn't live up to the standard of care, it was clear that what he did caused the injury. And so therefore the judge, the court in Smithers could have said, well, we don't know how that affected the standard of care issue. If I understand Dr. McConnell's argument here, is that even if that evidence had come in, and I'm trying to get back to Judge Gemma's question, even if that evidence had come in, it wouldn't have mattered, because if I understand Dr. McConnell's argument, because there's no causation, proximate causation for the failure to make the phone call. How do you deal with that?
I think I tried to deal with it in the brief, but let me see if I can this morning. The Smithers issue actually dovetails with the weight of the evidence, or the weight of the evidence issue, and what happened here was, it came out during trial. It never came out during depositions. It came out during trial that both Dr. Campbell, the defense expert, and Dr. McConnell admitted that because of the way the second ultrasound was interpreted, that was most likely a carcinoid cancer. But they never told Dr. McConnell that. It wasn't in the report.
Right.
Okay. Isn't that a problem more with the report than with the absence of a phone call?
No, the problem is that Dr. McConnell and Dr. Goldblatt just talked about the first report after the first report occurred, yes. But they didn't talk about it after the second report occurred. And so all that Dr. Goldblatt had to rely upon was the second report, which didn't communicate to him that it was most likely a carcinoid cancer, which is what she ended up having.
So what you're suggesting is that if they had a conversation, as far as causation, I understand what you're arguing. If Dr. McConnell and Dr. Goldblatt had talked soon after that second report was sent, Dr. McConnell could have explained, we've got a problem. This is a mass, not a cyst. it probably should be removed. Now, and if I understand your argument, even though there was evidence that Dr. Goldblatt also thought it should be removed, he didn't think it was a life or death situation where if he had heard, if I understand your argument, and tell me if I'm wrong on this, if he had heard from Dr. McConnell saying, we got a problem here, this looks like a mass rather than a cyst, he could then have turned to Ms. Janes and said, I know you don't want to do this because of your condition, but this is serious, and this could be cancerous, and we don't know unless there's a biopsy, and a biopsy involves an excision. And that could have led either one, to her saying, okay, do it, or two, Dr. Goldblatt not relying on Ms. Janes saying, oh, Dr. Newman's going to take care of it, but actually pursuing it and saying, did you take care of it?
Right.
Is that your argument?
Sort of. I agree with just about everything, but if you remember from the beginning, Dr. Goldblatt thought it was a mass. He thought it was a solid wall mass. He gets a report from Dr. McConnell that calls it a cyst. He has the conversation with her. She not only calls it a cyst, but she says it's most likely benign.
Right.
So as a result,
wants a second ultrasound.
And she wants a second ultrasound to see if it changes. She calls it, I believe, hypoechoic. Doesn't tell Dr. Goldblatt what that means, but then says in the second report it hasn't changed from the first.
Substantially unchanged, correct?
Substantially unchanged.
All right. So, and that leads to my go ahead. Go ahead from there and finish your.
So my point is, Dr. Goldblatt's, what he knows is, she told me it was a cyst when I talked to her the first time. I have a second report that has this term in hypoechoic. He obviously has no idea what that means because he doesn't do ultrasounds, he doesn't interpret them. And she doesn't tell him what it means. And he says it's substantially unchanged. So
he still says, I think you should excise it, but knows that Janes doesn't really want to do that, so isn't pushing it.
Well, the reason he says excise it, his testimony was, and I don't know if I got into this, but his testimony was at the beginning, was that the easiest way to deal with this is to just excise it whether it's benign or not benign.
I saw that in the transcript.
Right.
So I understand that, but it wasn't an impetus to do it. And this is more a matter of, your argument, as I understand, is more a matter of emphasis. If you think there's a real problem here, you're going to turn to a patient who's reluctant to do it and say, you really want to get this done. This is really serious.
Right.
If you think it may be benign or a cyst, you say, I think you should get it done, but, it's not, I know you're reluctant to do it, and, just do what you want to do.
There's one other issue, and that is, there really was an approximate cause issue in this case, because we had the only proximate cause expert. Nobody, the only proximate cause, we had Dr. Saab, who was a proximate cause expert, that said when she was treated originally by Dr. Goldblatt and Dr. McConnell, it was stage 1 and treatable. All you had to do, if it was removed, it was stage 1 and treatable.
Yes, but I talk about causation more in the sense of who's going to do the, if Dr. Goldblatt had said, I couldn't have been more strongly telling my client, my patient, get this done and get this done now. That might be different than saying, well, I didn't think it was, I thought it should be done, but it's, we don't think, I think it's still a cyst.
And then let me just, I'm over my original, but I'd like to say one thing in response to that. This goes into the whole issue about the weight of the evidence, is that the argument that one physician sends a patient to an imaging expert to get an opinion on an imaging study that he's relying upon, and to say that, to find the primary care colonoscopy, the primary care colorectal surgeon at fault, but not criticize or not find fault with the expert whose interpretation of the ultrasound he's relying upon, that's one of the reasons that I think that the jury's verdict is inconsistent.
But we don't have to reach we don't have to reach the weight of the evidence if we find there was prejudicial error on the exclusion of the evidence.
That's correct. I'd like to reserve the rest of my time.
You did say you had 3 points. Did we cover all of them?
And if you haven't, can you just give us the other?
Well, you know,
ones that have
the other point was obviously the jury verdict. The jury verdict was not, I don't believe, borne out by the weight of the evidence. And then finally, the issue with respect to whether or not the motion for new trial was timely filed. So, and that's been fully briefed. So, I do have. The other side filed a supplemental authority.
We've read that.
Okay, which I think is completely distinguishable from this case. The case that was being decided there was the motion for new trial was filed after a final judgment was entered.
Right, and then the idea was, if one party files a timely motion for new trial, and 6 months go by before the court decides it, does that restart the time for the other side to file?
Right.
Assuming that they didn't, it's not a motion for new trial. The second motion for new trial isn't because the judgment was changed.
Right. I don't think that case bears on this one, but I just wanted to address that. Thank you, Your Honors.
Thank you very much. Mr. Barnes?
Please the court. My name is John Barnes. I'm here on behalf of Dr. McConnell. I'd like to address also all three of the issues that were briefed, but I'd like to start with the issue of jurisdiction, which is lacking because the new trial motion was untimely. Nothing in Rule 59 requires a final judgment. The rule says...
even though Rule 54, I think, defines judgment as a decree or order that can be appealed?
54A says from which an appeal lies. It doesn't say from which an appeal immediately lies. And we know that's not what it means based on the Hanscom case.
So you're saying it means which may be ultimately appealable?
It has to have the capacity to be made appealable. And the Hanscom case is an example of that because the new trial motion that was filed extended the finality of the judgment without extending the time to file post-trial motions from the judgment. And there are other examples in the case law.
The issue there really was that the party filing the second motion for new trial was arguing that, well, gee, the first motion for new trial just told the time for me to file a second motion for new trial from the original judgment.
It's true.
And that makes sense if you don't want to do that. But if it's not a final judgment in the first place, then you wait till the final judgment gets entered. So the court knows, okay, I've got a final judgment in place. They've got 15 days.
It's not perfect. It's not a perfect analogy, but the principle holds true that the judgment doesn't have to be immediately appealable to start time on that. Okay. And other Arizona courts have recognized the distinction between a non-final judgment and a judgment that is immediately appealable under 12-2101, the Resca case, if I'm saying that correctly.
Anything else on the jurisdiction?
No, I'll move on to the merits.
I guess I have a question on the jurisdiction issue. If we have time, we'll ask Mr. Kasparek this as well. But my question is sort of the typical question: is there any case that's actually on all fours on this jurisdictional issue, or should this be an opinion in order to address this?
There's no Arizona authority on all fours. The reply brief cited to a few federal court cases that in a very conclusory fashion said that Rule 59 requires a final judgment, but those cases didn't analyze the issue. The Fifth Circuit, on the other hand, in the Tarleton v. Exxon case, analyzed the issue, and for the reasons I just mentioned, said that it'd be error to read Rule 59 as though it requires a final judgment. But if there's anything else, not anything else on that, I'll move on to the merits.
Go ahead, please.
Starting with Dr. Campbell's personal practices. This issue was waived because the plaintiff failed to make an offer of proof.
Well, but if the question incorporated the answer, and the answer was given, even though it was stricken, the judge knew what the answer was going to be.
Well,
right?
Offers of proof serve a dual function. They help appellate courts sort things out after the fact, but before that, they have to help the trial judge understand and appreciate relevance. And unlike the Smethers case, where relevance was obvious because the parties had briefed the issue in pretrial motions in limine, that didn't happen here. And relevance wasn't obvious from the face of the question because the question wasn't necessarily impeaching. And as I understand the argument, that's what the asserted relevance is.
But it also goes to the issue of the witness's credibility, right? He's asserting that the standard of care is one thing, and yet readily admits that he, as a typical part of his practice, does something that would seem to elevate that standard of care that he's testifying to. So how does that not go to the issue of his credibility?
Well, for all the judge knew at that point, Dr. Campbell had a perfectly good explanation for the difference. I mean, he might have said, I do that for client promotional reasons, to foster a good relationship with the people that send me business. The bottom line is the trial judge didn't see relevance on the face of the question, and he was forced to speculate on that in the absence of an offer of proof.
All right, so it wasn't within the context of that circumstance that the judge was able to understand the credibility of this witness might be central to the jury's interpretation of his testimony, so the only thing that really mattered was if it was directly relevant to the issue for which it was being asked? I'm kind of lost on that one, because I think I give Superior Court judges, I guess, more credit than that.
Well, I think the point is that the relevance has to be, the relevance to the credibility of the witness has to be evident from the question itself in the absence of an offer of proof explaining why it's relevant, which didn't happen in this case.
All right. I tend to go along with Judge Jones on that. If I'm a trial court judge and I hear an expert witness say, standard of care doesn't require the telephone call, but I do it, I think that's pretty clear that the credibility of the witness's statement about what the standard of care is at least in question for the jury to weigh. So I'm not sure the offer of proof is required at that point.
Okay, well, I would just cite to the case law that says that parties can't point to evidence on appeal that they didn't explain the relevance in the trial court. But even apart from the offer of proof issue, there's no prejudice that's evident from the record. These doctors, so the whole issue surrounds this follow-up phone call, and the doctors, in fact, did share phone calls after both of the reports.
I guess there's evidence, right, from Dr. Goldblatt that in February or March, some 6 months or so later, there was a conversation. I'm not clear on whether it's a phone call or a hallway conversation, I guess. But and if I understand correctly, the record, Dr. McConnell has no note of this nor any recollection of it. Am I on the right track there?
No, that sounds right. But Dr. Goldblatt did say that that conversation did occur, and that's the point, because it still didn't change his conduct. Dr. Goldblatt was clear that he understood the reports separate and apart from any phone call.
Well, the first report said it seemed to indicate it was a cyst, right?
The first report, no, said it was a solid mass. It didn't say cyst, and in fact, Dr. McConnell testified that she was very careful not to use the word cyst in the first
and they had a telephone conversation.
report. And then they had a telephone conversation, yes.
And what was in the nature of the telephone conversation was, do we need to excise this?
According to Dr. McConnell, she said that she would, when it comes to a solid mass, her recommendation would absolutely be to remove it. And she would never characterize something like that as merely a benign cyst. And so, back to my point, the purpose of any phone call was satisfied, because the two doctors, in fact, did have a conversation about the issue, and Dr. Goldblatt said that he understood his recommendation to remove the thing was unchanged. It was the same after both reports. So nothing in the record shows that the outcome would have been different had there been an earlier phone call.
But didn't Dr. Goldblatt also, in dealing with Ms. Janes, didn't he say, I continue to recommend this be excised, but I understand your concerns based around the potential downside of doing that?
And that was his recommendation as the treating physician. He assumed full responsibility for treatment decisions with his patient, and so that was his decision.
Go ahead. I'm sorry. Go ahead.
Dr. McConnell couldn't force him to do anything with his patient.
But let me see if I understand this. First report is, you're saying it says it's a mass.
Right.
Second report, if I read this right, if I'm writing this, it says the cyst was relatively unchanged from the last ultrasound.
That's what it
Second
says.
report says.
Yeah.
Right.
In addition to other things, but yeah.
Right. And there is some evidence that someone in Dr. McConnell's office may have told Ms. Janes that this was probably not cancerous. But that, be that as it may. So we get to the second conversation, and it does, I mean, the importance of this, I agree with you, and I've read the transcripts, that Dr. Groblatt says, I'm responsible, I'm a treating physician, I always thought it should be excised. But there's thinking about, in the context of this, he knows Ms. Janes doesn't want to do an excision because of her condition, unless it's absolutely necessary. He gets a report, the first one says it's a mass, second one says it's a cyst. He doesn't have a conversation with.
Can I correct you on that, Judge, though?
Let me just finish the thing.
Sure.
He doesn't, and then doesn't have a conversation with Dr. McConnell that says, you know, this is a problem. And it really needs to be excised. So he doesn't, as your opposing counsel indicated, he doesn't push Ms. Janes to say, you know, you really have to get this done, or double check with Dr.
Newman, I think.
Newman, to make sure it was done. So doesn't that raise the proximate causation? I mean, that this could have affected the proximate causation? Because
No.
maybe Dr. Goldblatt would have been more insistent with that Ms. Janes at getting this done?
Dr. McConnell's role was as an ultrasonographer. And with that comes the responsibility to provide the information as she understood it. And the first report said it was a mass. The second report said unchanged. It's a mass.
Cyst.
It said had slightly unchanged in that it had cystic properties, but it said that the mass was still hypoechoic.
That the cyst was relatively unchanged from the last ultrasound. Maybe I'm misreading it, but I thought it said the cyst was relatively unchanged from the last ultrasound.
I'm reading from findings, wall of the rectum. Oh, sorry, that was the first one. Findings, wall of the anal canal appears distinct from the cystic structure on the right rectovaginal wall, and then down under conclusion it says rectovaginal cyst, relatively unchanged.
Okay.
But before that she says it was hypoechoic, and she testified that everybody knows that means it's solid, just like the first report said, meaning danger. That's a big signal, danger.
Given the ambiguity in that, yes, there's a danger, or maybe there's a danger, maybe Dr. Goldblatt understood it, but it says a cyst. Wouldn't it make sense to, I mean there's an ambiguity there, right? Don't you think there's at least an ambiguity?
Not according to Dr. Goldblatt. He said he understood, and he said his recommendation was unchanged.
Is it your position then that a mass is the same as a cyst? You can refer to them interchangeably, and the one shouldn't bring on any greater alarm than the other?
No, there was actually quite a bit of testimony on that. The two are different, but they're not entirely separate. But a mass is certainly it signals danger, a solid structure mass.
In fact, in a solid structure mass, there's almost an anticipation that it has the potential to become cancerous, correct?
According to Dr. McConnell, she said all the literature says that means it's potentially dangerous, and you're going to want to get rid of it. According to her words, she said you're going to want to get rid of it based on that fact.
So in the second one, what had been referred to as a mass and should have set off these alarms becomes a cyst, which is a much lower. On the gradient, it is much less in regard to the issue of causing alarm. And there's really no follow-up at all to that issue, right?
But
I mean, there's a conversation in a hallway, or there's something that Dr. McConnell didn't even bother to write down in her notes, right?
well, she didn't have a record of the conversation, no, but Dr. Goldblatt did say that they talked it over.
And your point, if I'm following correctly, Mr. Barnes, is that Dr. Goldblatt took responsibility here. He said, I'm the treating doc. I made the recommendations. I knew what the reports meant. And because of that, your argument is there's no causation here. And therefore, any error on this, the exclusion under the Smethers case of this personal practice of Dr. Campbell, it just doesn't make any difference.
Dr. Goldblatt said, and the jury was entitled to believe him when he said, it was my call. It was up to him to decide with what kind of emphasis he needed to put on his recommendation. And so that's my argument.
Yeah. I think we understand your argument.
Okay, good. I'd like to briefly touch on the sufficiency of evidence because that was raised in the briefs.
It is raised. We didn't have time to discuss this in depth with Mr. Kasparic. My personal view is that the sufficiency of the evidence is one thing we do here all the time, of course, but determining if something is against the weight of the evidence is primarily a trial judge's purview based on being there. So I'll just tell you, at least for me, I'm not very apt to go down the inconsistent with, not consistent with the evidence route here, or in any other case. I think that's something a trial judge does and can do in granting a new trial, but not us very often.
I would just add to that, Judge, that even if appellate courts don't second guess the jury's assignment of weight to the evidence, and even if they were going to address that issue, it would require a complete record so that there would be no speculation about what the jury actually considered.
Let's say, if you don't mind, I believe you alluded to this in your, or no, I guess Mr. Kasparic alluded to it. I think it was in the reply brief. But let's say we agree that there was error and that it made a difference or could have made a difference, and so we're forced to reverse. What issues get tried on remand?
That a reversal would,
or maybe any issue of what gets tried on remand is simply not before us and really hasn't been fully briefed. So maybe we don't comment on that.
I would tend to agree with you, Judge, on that point. But I would add, there was a lot of talk about the judgments not being final, and they would sending this back would open up everything. All the judgments would be non-final at that point.
Well, it wouldn't open up the settlement with Dr. Goldblatt, would it?
That's true. But all of the elements of the malpractice claim would be up for grabs. The standard of care, the causation, and everything.
Would it alter the damages verdict? If simply the issue of distribution of fault was before that court, would it alter the damages? Would there be new testimony that would potentially alter the damages verdict, in your mind?
I don't know the answer to that, Judge.
Would it change the testimony presented, other than the factual testimony of the participation of the parties?
I'm not sure how to answer that, Judge. The issues with respect to damages were among the three physicians were that issue was decided with respect to all three of the doctors. I mean, it's contingent on a finding of zero fault with respect to Newman and McConnell.
Well, it sounds to me like you're saying this is probably an issue as far as the amount of damages and the allocation of fault and whatever's going to be tried on remand, except for Dr. Goldblatt's settlement, is something that that the parties would have to duke out in the Superior Court.
Yeah, if we remand, it's probably not something we're going to comment on.
And I don't have anything to add to that. Thank you.
Thank you, counsel.
Thank you, Mr. Barnes. Mr. Kasparic.
I have a lot to jam in here, and I'm going to do it as fast as I can. All
right.
To try to answer your questions. First of all,
I think I've worn those shoes before, so go for it.
Judge Jones, first of all, jury instructions were discussed while the evidence was still going in. There are three references in the minute entries to jury instructions being discussed. The last time that jury instructions were discussed in final was after all the evidence had been completed, but they started 2 days in advance.
But the court had been advised of the presence of Smithers and a potential jury instruction based upon the authority prior to the close of testimony.
No, it was on something different. One of my jury instructions dealt with the issue of whether or not I didn't ask for a jury instruction on the issue of personal practices because there was no evidence of it.
I did Smathers for another point.
Smathers was cited in one of my jury instructions for a different point, but it was there. But I can't honestly tell you that I discussed Smithers with the court on the issue of personal practices testimony.
Understood.
I can't do that. Now, with respect to the second report, which I happen to have here, the second report says this cyst appears hypoechoic. Okay? Well, the fact of the matter is and it's in my brief, and it's cited I cite to the testimony. By the time they got to the second report, Dr. Campbell, who was Dr. McConnell's expert, and my expert, Dr. Stein, both agreed that it was now a complex lesion, which has both cystic and solid features, and in the scheme of danger, it's more dangerous. It goes cyst, solid wall mass, complex lesion. And when you get to a complex lesion, it's more serious. And she doesn't even, Dr. McConnell doesn't even call it a complex lesion. That's one of the reasons I'm arguing that her second report not only calls it a cyst, which is wrong, but she fails to diagnose it properly as a complex lesion, as her own experts said that it was.
But why should we think that a telephone conversation would accurately and effectively supplant the report?
Because
if the report was below the standard of care or incorrect or whatever, I mean, you've had your day in court in that.
No, because it says hypoechoic, and nobody except an ultrasonographer knows what the significance of that is.
Dr. Goldblatt didn't know what that meant?
He wasn't specifically asked that question, all right? But he did testify. In fact, Dr. Alden, because when it became clear about this issue during the trial, Mr. Alden specifically asked Dr. Goldblatt, do you perform these tests? Do you understand what they are, and so on and so forth? And he said, it's outside of what I do. I don't do them. And finally, the conclusion in the second report was retrovaginal cyst, relatively unchanged from the last ultrasound. And the last ultrasound, she told him in the telephone conversation that it was a cyst and not a solid wall mass. Now, one other thing I want to talk about, this second conversation that they had shortly after, or 7 months later. Dr. McConnell's notes specifically says, discussed with McConnell last week, cyst between rectum and vagina.
Goldblatt's notes, you mean?
Goldblatt's notes, right. I'm sorry. So we know that in that conversation, she didn't tell him what she should have told him.
Okay.
So there was no, she didn't tell him that it was a complex lesion. She didn't tell him what the significance of hypoechoic was. She told him it was a cyst. So he still thinks
the first report says a mass, but the telephone call says cyst.
Cyst.
Second report says cyst, and 7 months later there's a conversation in which Dr. Goldblatt notes that it was referred to as a cyst.
Correct.
Right.
Do you agree, Mr. Kasparek, that if we were to agree with your position and remand, that we probably should we should currently stay away from what's to be done on remand and allow that to be dealt with at the trial court level and make its way back up here if it needs to?
I disagree completely. I don't think there's any. Actually, a retrial on damages would help my client, okay? Because I think I could get more damages. But the fact of the matter is, Damages have been tried, damages have been awarded. I think the only thing that gets retried is liability. I think what gets tried is the jury hears the testimony. The jury is told that in a prior proceeding, Dr. Goldblatt was found to be negligent. My client was found to be negligent, and now we're here to determine whether or not Dr. McConnell was negligent, and you're going to determine, if she was, what the percentages of fault are.
How can they determine what the percentages for Dr. McConnell are without determining what the percentages would be for the plaintiff and for Dr. Goldblatt?
They are going to determine that.
Why then would we tell them that some jury has already found that?
Because a jury has found it. I mean, that issue has been determined in this case. I mean, I'd love to say.
But if we were to remand, as you've asked us to do, we're setting aside the 0% finding as to Dr. McConnell. But how can we do that without setting aside the 25% and the 75%?
I'd be thrilled if you set aside the 25%, and then my client I can argue to the jury that my client wasn't negligent. So I'd be happy with that. I'm just trying to streamline the trial and not get back up here to the Court of Appeals a second time.
Well, we're not saying that's what we're going to do, and we can't help as lawyers but be curious about this, but it hasn't. I don't believe these issues have been fully briefed to us, and it's not likely we're going to comment on them. Anything else real quickly? We are at the end of our clock here.
Your comment about, the weight of the evidence is the trial judge who gets to see everything. I just want to remind the court that Judge McVeigh, who tried this case, retired before the motion for new trial was heard. So the judge who determined the motion for new trial hearing, he didn't hear the witnesses, didn't see the witnesses, and he didn't have a record before him except for what was cited in the briefs.
But again, that's a good point. But if we decide that there was error on denying the motion for new trial because of the exclusion of Dr. Campbell's personal practice, we don't need to reach that issue, do we?
That's correct.
Okay.
You don't. Thank you, Your Honors.
All right, we will take this matter under advisement. Thank you, Mr. Kasparic and Mr. Barnes. Your briefing has been very good, and your arguments have been very good, and we appreciate it.